Test. Yeah. Yep. You're good.
I'm okay. Okay, well, thank you very much. Good morning. Well, okay, we got to get. Just so you'll know, ladies and gentlemen, this is my first meeting in years. And so if anything is out of the way or if I need help, my colleagues, Mr. Ververt and Mr. Otto have agreed, and staff obviously to help. So we'll start the meeting then. Thank you. Good morning and welcome to the Committee of Adjustment hearings for Rural Panel 3. We are a City of Ottawa quasi judicial tribunal that holds public hearings to consider Planning Act applications, including minor variances to the zoning requirements and consent to sever land. Our hearings are now in person at Ben Franklin Place, 101 Centerpoint Drive. We also enable remote participation by video conferencing for our registered speakers. We are live streaming on YouTube, and the video will be archived and available for future viewing by the public. My name is Bill Hunter. I'll be chairing today's hearings, and you can address me by my name or as chair. With me are panel members Martin Vervoet on my left and Terry Otto on my right. The procedure for the hearings will be as follows. Listed on the agenda and appearing on screen from time to time are the applications we'll hear today. For the sake of efficiency, I may deal with the agenda items in a different order. Panel members have reviewed the planning reports and any written submissions in support or in opposition to each of the applications. Today, we'll hear any oral submissions relating to the applications. As part of the statutory public notification requirements, each applicant was required to post a sign on the property in question before the hearing. They also had to confirm in writing that they did so, or the need to swear or affirm on oath today that they've fulfilled the sign posting requirements. I'm advised that all the signage has been properly and appropriately placed on the properties today, and so that's not a problem. The panel may ask for a brief presentation of an application, followed by questions for the applicant and city planning staff. We will then hear from members of the public who have registered to speak, and we also have questions for them. Finally, the applicant, who has the burden of proof, will have an opportunity to make final comments in reply. Please address your comments to me as the chair, starting with your name and spelling if necessary, and your municipal address for the record. All presentations are limited to 5 minutes. Any exceptions will be at my discretion. At the end of the hearing, the panel may either make an oral decision or we may reserve, which means it won't be delivered today. In either case, and within 10 days, the Committee of Adjustment will send the official written decision and reasons for it to all the parties, participants, and anyone else who has asked for a copy. Does anyone have any questions about the procedure we will be following today? Okay, we have several applications to hear today, but first we need to deal with some preliminary and procedural matters. Are there any declarations of interest of the panel members? There being none. Confirmation of minutes of previous hearings. Panel members, have we minutes of the previous meetings to review? To adopt?
Yeah, I think there are 2 dates. Staff can confirm those dates.
Yes, May 3rd and May 17th minutes need to
Okay.
be.
Are there any comments, members of the panel, about those? Are they approved? Yes. Okay. Thank you. The next, withdrawal or adjournment requests. The committee has received a request to adjourn, which means to postpone on a different day the hearing for them, and that is number 3. For the committee has received no requests to adjourn the other matters. Are there any other requests or questions about the procedure for today's agenda? Okay. Turning to the applications that are before us today. I would like to deal with, first of all, the adjourn request. This is from staff and it's for the Campbell Reid property. That's number 3. Is there the applicant here to speak to that, please?
Good morning.
Morning.
My name is Paul Robinson, the applicant for the property at 4 Campbell Reid Court. To my right, I have Bruce Firestone, who's the development manager for the project. And to the right of Mr. Firestone is the property owner, Dr. Olander.
Welcome.
Thank you.
Would you like to speak to this?
Yes, we would like to proceed. There are 2 variances that are being sought for this application, which is also subject to a site plan application. The variances are a very small variance related to a lot area and also a fairly small variance related to lot width based on where the lot width measurement is taken from. There are issues related to the official plan status of the property. Changes occurred late November of 2022 on this property through the province's approval of the city official plan, which put it into a different designation. We have met with city policy staff and the city file lead planner on this. And the city policy planner, Mr. Vanderlind, is here today. There are modifications to the official plan going forward in the next couple of weeks to planning committee and council that will rectify this issue. And this property is literally the only property in the Canada North area. And I believe there may, Mr. Vanderlind can confirm, there may be one other property in the entire city that falls into this sort of scenario whereby we cannot proceed on a site plan application if there are any variances required. The variances are very small variances. They're related to the shape and size of the property. They're not related to the type of building that is being built or its setbacks, its height, its density, or its parking. It's all matters that are inherent to the property, its shape and size now. Thank you.
Mr. Chair, may I just add a quick comment?
Yes, please.
Thank you. Dr. Olander has been a veterinarian in the Canada North area for several decades. He's currently in a rental property on March Road. And I believe there's a development application that's coming forward to the city, or is actually in the city's hands right now to redevelop the property. Dr. Olander engaged me and Paul and others to help him construct a new clinic in Canada North at 4 Campbell Reid Court. He's been at this process for over 2.5 years now, and through no fault of his own, or in fact, anyone in this room, the province of Ontario unilaterally decided to expand the urban boundary, which meant that Dr. Olander's property, which passed all the tests required for site plan approval as a rural property, is now considered urban. And the city of Ottawa, will hear from Mr. Vanderlind shortly, is now going to deal with that issue. Otherwise, Dr. Olander will be in serious jeopardy of losing his clinic. He has a notice provision in his lease, which gives him 15 months to relocate. He has 15,000 families that rely on him and thousands of animals. It will take 12 to 14 months to build the new clinic. And we're under serious time constraints here. And we think we are prepared to argue the motion in front of the committee, and we hope you'll consider that.
Okay, thank you.
Thank you.
Anyone else from the applicant that wishes to speak to this matter before I ask planning for their comments? No, thank you. Planning staff, could I have your comments, please?
Chair, I'll ask that
I'll ask that my colleague Robin Vanderland be invited to speak to this matter.
Thank you.
Thank you, Mr. Chair and fellow members of the Committee of Adjustment. It is very atypical for a senior policy planner to attend a meeting like this, but it is, however, a pleasure to have introduced myself to you earlier. I want to speak I can only speak factually about what it is that the city is doing. I can't give you a position on where we are.
Excuse me, Mr. Chair. Right now, we're just dealing with the adjournment request.
Yes, that's right.
If with your permission, I'll continue. So
Well, sure. Is what you're going to say deal with the request that planning staff has made to have this matter adjourned? I know there are reasons why it was asked for. I have the letter, the email.
right. I'd like to speak with Jack for a moment, if you don't mind.
Yes, okay, sure.
Apologies for the delay, Mr. Chair.
That's fine.
I defer to Jack for the moment. Thank you.
All right, thank you.
Thank you, Chair. So the reason I requested an adjournment was because of the current official plan policy does not permit this application to go forward, as it needs to be removed from the future neighborhoods overlay before an approval can be sought. However, there is council intent to address this policy. So the adjournment request is to allow for time before the official plan policies are changed. However, if the applicant wishes to proceed today, that's their choice and the committee's choice.
Okay. Any questions from panel members? I have one. If an adjournment is granted, how long approximately will it take before? Let's assume it goes ahead, that this meeting, I think it's July 4th or the 6th goes ahead. Yeah, well, whatever. Let's assume it goes ahead. And how long approximately will it be before the applicants would be able to proceed with this matter?
I believe if it has to go to the ARAC committee, so it's not July 6th. It's later. When it does reach committee, the decision will be rendered at that time, and there will be a bylaw that is issued afterwards, and then which is typically at the next meeting of council post the approval, and then there's a 28-day appeal period.
Right.
This is a rather complicated set of amendments that is coming forward. I was directed by Councillor Clark and the rest of council to amend the official plan, not only just for the application that is before you now, but we understood that quite a number of properties had been added to the future neighborhood overlay, and we had not anticipated the overall impact to minor applications of placing a future neighborhood overlay in place. I can elaborate on that perhaps if.
Well, no, that may be going a little bit beyond
Yeah.
what we need to know today. Thank you very much. Does the applicant have any questions?
In terms of timing, my understanding is that this would be, and Mr. Vanderland can confirm, This will be scheduled for July 12th at council. Typically takes about another week for a bylaw to be drawn up, and then a 28-day appeal period would occur, which is taking us into mid-August. So based on the timing that Mr. Firestone listed in terms of the timing restraints that the veterinary clinic has, we'd like to be heard today so that we don't lose any more time. Thank you.
Okay. Just if I may ask another question of planning, if it does proceed today, even though there are further steps have to be taken, can the matter go ahead?
Through you, Chair, that would be the committee's decision if it goes forward today.
I see. All right. Okay, thank you. Any questions, panel members? Staff, any questions? No, okay. Well, thank you very much. Panel members, can we reserve the decision? Well, do you want to proceed? Yes, okay.
Well, Mr. Chair, in my opinion, it's ultimately the applicant's call. So if they want to proceed today, I would be prepared to go ahead. I'll defer to you and to Mr. Otto.
Mr. Otto?
I concur. It's totally up to the applicant. If they want to proceed, I'm totally willing to go ahead.
So do I understand that the feeling of the panel members is that we go ahead today and we don't reserve the decision, or we do reserve the decision?
No, we go ahead and make the hearing.
Okay. Okay, so we're going to go ahead.
Thank you very much.
Thank you.
Thank you.
Okay, we will come back to this for a hearing, but we'd like to deal with what we believe is an unopposed matter of Flewellyn Street, and this is I think it's number 5-4 on the agenda. Is there anyone here with respect to that matter? There may be virtual persons involved to staff. Are there?
Yes, Mr. Chair, I believe the agent is online.
Okay. And the agent is that Mr. Gibson? Yes. And Mr. Gibson, would you like to make comments? I understand it's unopposed.
Sorry, sir. Yeah, I'm here. Can you hear me now?
I can hear you now.
Yes, I'm the agent for the property. Right. Still starting up here. There we go. There I am.
We are, yes, I can see you, Mr. Gibson, and hear you. This appears to be unopposed. There are no comments. There's no objections. There are conditions that will be placed in. You know about those.
Yes, sir. I have them written down here.
Right, okay. Is there anything else you'd like to add?
No, if the panel is happy with it, like I said, I think you're under the understanding it is a simple, just lot line adjustment that I'm trying to do to extend the property line on some family land that's potentially going up for sale soon. And really no ideas to do like a second severance. It's going to be adjusted, accepted into the property I currently have. So.
Okay. Planning staff, any comments on this?
Good morning, Chair. I'm just calling it virtually here.
Okay, yeah.
No, planning staff have no additional comments or concerns for this one.
Okay. Panel members, any comments? Concerns? No concern. Can we?
Mr. Chair, I just have a question for planning in regards to the first 4 conditions that have been requested. this is basically a lot line adjustment and normally there's just the two standard CFA conditions apply. Why are they asking for these extra things? I understand the road widening is new and that's fine. I can accept that one, but does the client realize these other conditions as well? And are they opposed or are they okay with them? But it
Well-
just seems to me we're putting more and more conditions on lot line adjustments than are necessary.
Excuse me, Mr. Otto, if you could you mention the conditions that you're concerned about? I'll see if I can find them.
Yes, the first one is file a lot line adjustment documents. The
Okay.
second one is notice on title, quality and quantity of the groundwater. 3 is notice on title of thin soils. And then a 4th is the road widening of 13 meters on Flewellyn Road, which now are standard conditions or requests.
Now, correct me if I am wrong. Are those conditions regarding the groundwater and the soil, is that potentially if I'm going to do anything with the land outside of just leave it as a vacant open property? Or is that what I have to do even just for this continuing with what I'm planning on doing now?
So through you, Chair, those notices on title are for potential future owners of the property if they want to do something with it, I believe.
You okay with that, Mr. Otto?
I'm okay with that. I'm okay with that. It's just whether the client is prepared to do that. Thank you.
Mr. Gibson, are you okay with those conditions?
Yeah, actually, if Mr. Tiff could explain that, is this something I need to get done, or if someone who potentially buys my property, if I put it up for sale, that they will require this to do anything with the property?
Planning staff?
Yes, Chair. So you would have to register these yourself.
Okay. Now, is there a cost through the city for that, or is that something done with my application process?
1 second, not aware of the costs.
Sorry, could you repeat that?
I can just add through the chair that there's no additional cost for registering these through the city. You may need to retain a lawyer to have the agreements prepared, but there's no cost from the city for preparing these agreements.
Okay.
Okay,
Yeah, that seems fine, Mr. Under. Thank you.
okay, thank you very much. Okay, members of the panel, can we approve this? Approved? Yes, it's approved. Thank you very much, planning staff and the applicant, Mr. Gibson.
Thank you, gentlemen.
Could we move to Third Line Road? And Mr. Robinson, again.
Morning again.
Good morning. Would you like to speak to this matter?
Yes, I would.
Okay, please do so.
Thank you. Could the coordinator put up the PowerPoint, please? Thank you. So the property in question is at 6780 and 6788 Third Line Road, just south of North Gore. Next slide, please. So the image on the left is from Google Earth, and the properties in question are shown in blue. And then further on the right-hand side is an image from Geo Ottawa of the property. So what has occurred is the smaller of the two properties has a house on it that was built in approximately 1976. And then the larger of two properties, which wraps around the smaller property, has until recently been a vacant lot. In 1987, the lot where the home from 1976, it was became a separate lot. And then at some point in 2003, the other lots that are shown in yellow were severed from the larger farm parcel that is to the left of the lots in yellow. Some unusual things occurred back in 2003, and there is a document on the slide presentation indicating that the two lots in blue actually merged on title in 2003. My client, Mr. Davidson, bought the property a few years ago. All the documentation that he was given showed that this was two separate lots. Geo Ottawa shows it as two separate lots. We have documentation in this PowerPoint presentation materials from MPAC, the Municipal Property Assessment Corporation, showing that it's two lots. Most importantly, in September 2022, my client, Mr. Davidson, applied for and got a building permit for the larger of the two lots that wraps around the smaller lot. That home is almost complete. And as a result of the completion of his new home, he put the lot on the smaller property up for sale. He got he arranged for somebody to move there. It's a family that's moved from Richmond, Ontario to this property. And when the lawyers started looking into the documents to secure the purchase of the smaller lot from Mr. Davidson, it was discovered that back in 2003, a merging on title had occurred. And as a result, the family have moved into the house. They are technically still tenants and they do not own the property. Mr. Davidson and his family are living in the almost completed home. And we are just trying to get this re-severed. And that is the crux of the application before you today. You'll probably hear from Mr. Graham about some of the policy issues. I'm not sure if when in 2003, if these lands were in an agricultural rural designation. And now the only way it appears to do a severance in this designation is through a farm consolidation. And that is not the situation here. It's we have a predicament where a family has moved in. And Mr. Davidson and his family are wanting to move into their almost completed home on a separate lot. We're just trying to re-sever what had been severed many years ago and unfortunately merged on title. If we could go to the next slide, please. So this is the lot that was created in 1987 to make the home that had been built about 10 years earlier on a separate lot. Next slide, please. So this is the R plan from 2002, which severed the lands which had an address of 2153 Lockhead Road into 4 parts. And parts 2, 3, and 4 all have homes on them. Part 1 is what occurred in the merging on title. And where the words part 1 are, that is approximately where Mr. Davidson's new home is. And then where you can see to the right of that, there's some other text that is highlighted in yellow. That's approximately where the other home that was the original home on the property is located. Next slide, please. These are the Committee of Adjustment decisions from 2003, where it had, I think the actual application was 2002, but it took till 2003 for it to all be all the conditions cleared. And then the other document on the right, signed by the Secretary Treasurer of the committee at the time, indicating that the two properties had now merged on title. Next slide, please. This is the draft 4R plan that was done in May. It was only in April of this year that Mr. Davidson and his lawyer and the purchaser of the lot shown in green became aware of the merging on title. It had been done under a previous ownership, and Mr. Davidson was not made aware of this. So this, we quickly got this all organized and filed the applications. Parts 2 and parts 4 are fairly narrow road widenings that are to be dedicated to the city, so that there's a 13-meter distance from the center line of the road to the new parcels. And we're in support of the conditions that are listed in Mr. Graham's report, should the committee support the application. Next slide, please. Here's some photos. You can see I took these on May 1st. On the left, far left in the distance, you can see the new home. This is, I guess, about 7 weeks ago it was taken. And then the second photo is closer, showing the home. It is inhabitable. The two photos on the right show the home that is where the people who want to buy the smaller lot are. That's the home on the property, taken from the driveway and then taken along Third Line Road itself. Next slide, please. This on the left is the building permit that was issued for the home that you could see under construction. It was issued on the 21st of September of 2022. It never cropped up in anything that was reviewed by City Building Code Services that there were any issues in terms of ownership and merging on title. So Mr. Davidson filed this application and nothing ever came up. And then on the right, there's been inspections done in the normal course of events. So things have been progressed that way. Next slide, please. On the left is the tax bills. They have separate addresses. They have separate roll numbers. And I believe that on the right is an email and from MPAC to Mr. Davidson, indicating that the properties have unique roll and parcel PIN numbers. And also, I believe it indicates that one of their separate lots, according to MPAC, and they have no issues with it in that regard. So that's my presentation. Their staff are recommending a refusal based on the official plan policies. We're trying to clean this up. We've got a predicament where we've got two families that are wanting to live in homes that at one point were separate lots. Merging on title occurred. And I only got the staff report that you have in front of you in the middle of yesterday afternoon. I did have a discussion, which is quite late. I did have a discussion with Mr. Graham yesterday afternoon on the phone after I got this. He indicated that there had been, I guess, quite a few discussions between himself, his senior planner, and city legal, and there didn't really seem to be any solutions that they could offer to this. We're hoping that the committee will see the reasoning behind this and what has occurred, and that there's been nothing has been done untoward by our client. It's matters where merging on title occurred before he owned the property, and he was not made aware of it. He would not have applied for a building permit if he knew that the properties had merged on title. Thank you.
Thank you very much. Planning staff comments, please.
Thank you, Chair. Yes, so as Mr. Robinson indicated, it's our understanding that in 2003, this was a severance done under the Port Pocket provision, and then the further parcels were created afterwards. And the intent was for the 6780 and 6788 lots to merge with a lot line adjustment. From the records we have been able to see, city legal staff have confirmed that the lots are merged on title, and that any further severance would need to go through a Planning Act application. And so that's the Planning Act application we have today, the request for severance. Under the current official plan, this area is designated as the agricultural resource area. And as such, the only residential lot creation is through the surplus farm dwelling policies. And those policies would not be applicable here, as this is not this is not a farm consolidation situation. This is two separate parcels. So this situation does not comply with the official plan. It's my understanding that the building permit was issued in error. However, it was issued and the construction began, and there are now two families living in there. However, the position of the planning department is that this does not comply with the official plan, and so we cannot support it.
Okay, thank you very much. Panel members, any questions? The applicant or planning staff?
Just a few questions from planning staff. So just to be clear, the proposed severed lot was created, I guess, previously under a poor pocket policy. So judging from the slides presented by the applicant, there's no agricultural activity taking place on that lot, right?
That's correct. Those lots are not being used for agricultural uses at this point. However, it's still designated as such in the official plan.
Okay. And I understand the zoning on this should be AG instead of AG2, is that correct? I believe.
That is correct.
Okay. Now, the provincial policy statement does allow severances in limited circumstances for legal or technical reasons. Do you see this as falling into that exception or not?
My understanding is that would only be for lot line adjustments and not creating new lots.
And I understand too that the Planning Act has been amended to avoid these types of inadvertent mergers recently. Are you aware of that?
I believe one of those situations is for a death and the having the deceased person removed from the title and that creating the lot merging situation. However, I don't believe that is this particular scenario.
And I guess, does the zoning permit 2 houses to be on the property?
The zoning could permit a secondary dwelling unit, but it would require variances to be permitted, and it would not allow the sale of the second dwelling.
Okay, so the property still doesn't comply even
Correct.
after this. Okay. Those are all my questions.
Thank you, Mr. Otto. Do you have any questions?
No questions, thank you.
Okay. I have one of the applicant, the merging, I understand it was husband and wife owned one and see the husband or the wife owned the other. Unfortunate marriage breakdown and everybody was more interested in child custody probably and support than what was going on in title. Is that basically correct, sir?
That's my understanding, and that's occurred under a previous ownership, not the current owner. One property was bought in one spouse's name, and the other property was bought in both spouses' name, and one spouse left the area or left the property, and then they took it off, and people didn't realize. That's what my client has been told, and what his lawyer has discovered. Unfortunately, as you can all imagine, this occurred 20 years ago. It's all in the sort of depths of time, and a lot of people who were involved in those matters are not available. So
Right. Okay. Any questions arising out of that? Planning staff? Yes.
It is my understanding that the properties were intended to merge in 2003 through the Committee of Adjustment decision, and that they were never intended to be separate parcels.
All right. And that's the decision that was shown just a short while ago.
That's right.
Yes. Do we have a copy of that?
Um,
A hard copy? I didn't see it unless some of my colleagues can. I mean, I saw it when it came up here. Part of it was superseded by, the pictures of the panel as it is now. Is it possible just I don't, we may reserve on this. I think it likely have to talk to my panel members, obviously, but is it possible just to get a copy of this, a printed copy of paper?
I can make those documents available today and send them to the committee.
Yeah,
Yeah,
okay, because
thank you.
and the planning staff, that is what you're relying on to say that there is an intent to merge these properties.
My understanding is that the lots were intended to be merged from that 2003 consent, and that as a condition of that consent, a further Planning Act application will be required to convey them separately. And so this is that application coming in to convey these separately, and we cannot support it at this time from the official plan perspective.
Yes, I understand that. Okay.
I believe that between the time of 2003 and 2023, the official plan designation on the property has either changed or policies have been put in place that would not allow, would only allow a farm consolidation severance. We're caught in a situation here where building permits have been issued, houses have been constructed, and this seems to be the way to rectify it. And there are policy roadblocks, but we're trying to appeal to common sense here that allow the two families to have their own property. And as Mr. Hunter asked, you can't, or Mr. Vervoort asked, you can't have two primary residences on one property. You can have a primary residence and a secondary dwelling unit, but these are both primary residences. Thank you.
Yes, I saw that in the photographs that you showed us. Okay. Anything arising out of that? No. Yeah, can we reserve? Is there an agreement that we will reserve? Thank you, Mr. Robinson.
Thank you very much.
Thank you, planning staff too. Uh, 7552 Copeland Road. Anybody here on that?
Morning, Mr. Chair. My name is Scott Carruthers and I live at 7552 Copeland Road. And this is my neighbor Ian Watson, who lives at 7512 Copeland Road. This property, our properties are located near Munster Hamlet in the southwest end. In between Ian and myself is a 67-acre parcel of land, which I also own. It's vacant at the moment, and it will be in the future if I have. It's a vacant piece of property. And last year, Ian and I came to sort of a verbal agreement that I would sell him 6 acres of my land immediately behind his house so that it would increase his property size from 4 acres to 10 acres. And I would reduce my 67-acre piece of property down to 61 acres. My property wraps around behind Ian's property. So the parcel that I would like to sever or sell to Ian would actually be located immediately behind his current property, and would not be up against. There are 2 conditions that the planning staff have put on file, and I'd like to speak to them both. And the first one being the condition 1.4 for road widening. I had great difficulty understanding the intent behind this condition, and my solicitor pointed out that the section of the Planning Act that the city is quoting in this clause actually talks about subdivision plans for development. And this is clearly not the case. Not only is Ian not planning to develop this land in any way, he is not allowed to under the current zoning of the property. Also, as I've already mentioned, this 6-acre parcel of land has no frontage along Copeland Road. So why would the city be requesting additional road allowances for a small parcel of land that is set way back in the woods? I explained this to city planners at length in January of this year, so I'm surprised to see that it is being recommended at this point to the Committee of Adjustment, and I'm requesting that this clause be removed from the conditions. Would you like to speak to this now, or should I go ahead and mention my second?
No, I think if you go ahead and mention your
Okay.
second.
The second condition I would like to challenge is condition 1.5, which is the scoped environmental impact statement. In January of this year, a city planner put it in writing to me that an EIS would only be required as part of the building permit application in a situation where land was to be developed. So I was surprised to see that this is now a recommended condition. Not only would this be an expensive and time-consuming burden to lay upon me, but the end document would have no relevance as the property is clearly not to be developed. This land is currently used for recreational purposes only by Ian and myself in walking, skiing, snowshoeing, firewood, etc. And the land usage will not change regardless of who owns it. The city does not require an EIS to regulate the land use for this piece of property. The zoning already regulates what can and cannot be built. Both Ian's property and my property are zoned identically, and in fact, they were once part of the same parcel. All I want to do is to redraw the lot line, making no changes to the existing flora, fauna, wildlife, natural features of the land, etc. So I asked, what good would come from the city having an EIS for a 6-acre parcel of land that has no proposed development? If development was to be proposed at some time in the future, I would assume that the new developer would be required at that time to provide such a document, but not now. So I'm asking that this clause please be removed from the list of conditions. Ian and I are available for any questions that you may have.
Okay. Planning staff, could I have your comments, please?
My colleague, Mr. Teet, will be addressing this application.
Yes, thank you.
Thank you, Chair. Regarding the road widening, this is just required for any planning application, not just for subdivisions. So that's why we're requesting it here. And for the EIS, we would just be requesting a scoped EIS. It's just a form that you can fill out yourself, just so that you can show, what's on the property, if there's any species at risk that could be there. Through some further discussions, this wouldn't actually be caught at a building permit stage. So we'd want to guarantee that the forest would be protected at this stage.
Yeah, thank you. Members of the panel, any questions? The planning staff or the applicant?
I guess the only comment I would like the applicant to be aware of is in regards to the road widening. They consider anything now to be subdivision. So a lot line adjustment is considered the same as a subdivision, so they're requesting road widening. And to be fair, to let you know, if you want that removed, we can probably strike it, but then you will have to defend that at a later date at LPAT. So, and I think the scope EIS, you can just give them a handwritten diagram or description as to what the property has, and that would be fulfilled easily. But again, that's just for your awareness that you should know.
Having not gone through this, are there costs associated with the road widening process? Because I'm really not familiar with this at all.
Planning staff, please.
Yes, I believe for the road widening, you just have to have a plan of survey done. So you have to just pay a surveyor to have that added.
Does that need to be done now? If this is approved?
Yes.
I'm sorry, I couldn't hear. If that's left in there, if the condition is left, does the survey showing the road widening have to be done now? Or does it need to be done at such time down the road that the road is widened?
It would have to be done, as a condition of approval now. Yeah.
Now, yes. Yes, sir.
I'll just clarify that the condition would have to be fulfilled within 2 years after approval of this application. So the applicant would have 2 years to provide the survey to the committee for approval.
Right. Okay. Any further questions, panel members? Any response applicants? Give you the last word, folks?
It just seems very odd that, there would be no more or fewer persons traveling up and down Copeland Road. And if this sale goes ahead. So I fail to understand why the city would need additional land to run additional services for a simple lot line adjustment on a piece of property in the middle of the woods. I just fail to see the relevance. I understand it's in your policy. I guess I'm questioning the policy and because this is a real burden for us. The total value of this transaction is $30,000. I'm talking $5,000 an acre times 6 acres. Nobody's getting rich off this. We simply don't have the money for additional, expenses if they're not warranted. So this may be the end of the deal if we end up looking at a, you know, a large dollar conditions being placed upon us. We're simply trying to adjust the lot line, you know, between consenting neighbors.
No, I understand that, as my friend Mr. Otto indicated, though, there could be an appeal if we strike that condition. And then that means appearing before another board to argue it. And you may not win that, you may lose the appeal, and so I guess, anyway, I'll leave that up to you, members of the panel. Should we reserve on this? Yes, Mr.
Thank you for your
Reserve.
time. Thank you.
Thank you very much for coming and your comments. Fine and staff. Doyle Road. And I think the application has been amended, if I'm correct. Is that correct?
That is correct, Mr. Chair.
Okay.
My name is Christine McQuaig, planning consultant acting on behalf of Suntech for this application. And our address is 43 Eccles Drive. And
Okay.
to my right is Ms. Corinne Taransky, representing Suntech.
And you were here at the last hearing, or your client was here at the last hearing, and
My client was here at the last hearing. I was brought into this file a couple weeks ago, but I've reviewed everything and been briefed and here to speak to the application. And to your question at the start, the variance has been revised from an increase of lot coverage from the permitted 20% to 30%, whereas previously 40% was requested.
so the current coverage is 30%,
The current coverage is 20%.
20%.
And the requested coverage is 30%, an increase in 10% from what's
Okay.
permitted.
And that's what you've revised.
Correct.
Okay, would you like to speak to this matter?
I would, Mr. Chair.
Please go ahead.
Coordinator can pull up my presentation. So the property in question is 5541 Doyle Road. If you can jump down to the next slide, please. So the subject site is located on the east side of River Road, sort of, you know, towards the Cars Osgood area. Next slide, please. This is a outline of the property itself. Doyle is to the south and River Road is to the west. To the east is a sort of the Osgood pathway system that runs diagonally along the eastern border of the property. There are ag lands to the south and east, and rural zone continues to the north and west. And then if you jump down to the next slide, I've just sort of blocked in what the expansion to the greenhouse that is being requested would sort of look like and fit onto the property. Next slide, please. So the property is currently zoned rural countryside within the rural transect in the City of Ottawa official plan. It's zoned RU. It is currently developed with a single detached dwelling. There's a garage and the existing greenhouse on site for the use by Suntech Tomatoes. Next slide, please. This is the draft reference plan that is also sort of acting as the site plan. The box towards the back of the property is the proposed expansion that is being contemplated. As noted, this site does front onto two roads, so on River and on Doyle. And then to the rear of the property, it abuts a pathway system. So in terms of location and context, it doesn't have many abutting neighbors. Most of the abutting uses are sort of non-impact scenarios from expansions and changes to the property. Next slide, please. So these are some images of the site, and I sort of identified in a black outline where the expansion would be, images from Doyle Road. And then if you look at the image to the top right, this is from River Road taken along the interior lot line, and you can see the significant vegetation of trees along that interior side that currently buffers the existing greenhouse from the abutting neighbor to the north. Next slide, please. So the proposal here being contemplated is to add an extension to the existing greenhouse to support the production of the local food of tomatoes and cucumbers. It will be located towards the rear of the lot. And I say rear of the lot, but it does abut Doyle Road. So there is no sort of, there's no two interior lot lines that it abuts, only one. It is proposing to increase the lot coverage from 20% to 30%. And the extension does not abut any other dwellings. On the property to the north, not shown in this aerial photo, there was a barn constructed in the back part of the property, somewhat in line with what the extension would be. So no habitable dwellings, just sort of more rural activity type uses that would be abutting. Next slide, please. So the variance we're seeking today is to permit an increased lot coverage of 30%, whereas the bylaw permits a maximum lot coverage of 20%, so an increase of 10. Next slide, please. So I'll review the VOR tests. I understand that there was a letter submitted with this application. I want to do a more fulsome review of the VOR tests, so I'll take you through that quickly. Understanding I only have a minute left. The difference between lot coverage of 20% and 30% is not significant given the context and the zoning provisions that are greatly exceeded. And by that, I mean with respect to the interior yards and the rear yard and the corner yard. The coverage applies to a greenhouse. It does not apply to significant, barn activity or multiple different structures and uses. It is simply the expansion of a greenhouse. There are no abutting dwellings to be impacted by the presence of the expanded greenhouse. The expanded greenhouse is set back 40 plus meters from each of the property lines. The growing of produce, whether it's in a field or in a greenhouse, is the same intensity. The difference here that we're looking at is that the greenhouse, because it's a building, is subject to provisions in the zoning that a field is not. The intensity is not related to lot coverage in this particular scenario. Based on the use, the type of building, the proposed increase in lot coverage, in our opinion, is minor. Next slide, please. So the variance meet the intent and purpose of the official plan. The rural countryside designation allows for low intensity farming uses with an intent to support industries that serve local residents and to limit residential. No further residential is requested.
Excuse me, if I can interrupt, your time is up, but how much more time would you need reasonably?
Maybe a minute and a half.
Minute and a half?
Yeah.
All right, panel members? Yes.
Thank you. By the nature of growing produce, the intensity of farming is low, especially in consideration of the difference between 20 and 30%. The use supports local and regional residents. The use supports the rural economy and local food production. The site abuts agricultural lands and agricultural designated lands. And so the context of an extra 10% in lot coverage for the production of produce, given the context, is highly supportable. Next slide, please. Does the variance meet the intent and purpose of the zoning bylaw? The lot coverage performance standards is intended to restrict overdevelopment relative to the size of a lot and partly to limit impervious surfaces in order to support stormwater management. The difference between 20 and 30% is not material significant given the context, the location, the type of building, and the use of that building. The expansion is located towards the rear and is not in proximity to existing dwellings. The building subject to the provision is a greenhouse, which is used for production of local food. Produce can be grown without the use of a greenhouse and not be subject to lot coverage considerations. And so the site is not overdeveloped and is not over-intensified. The development can occur with or without a building. Suntech will be incorporating rainwater collection systems and drainage ditches in order to improve the use and management of water on their site. The increase of 10% maintains the intent and purpose of the lot as it is not overdeveloped. The expansion generates no additional impact, and given the nature of the use, the management of stormwater will be improved. Next slide, please. And then lastly, is the variance desirable and suitable? The variance supports local food production. It supports the local economy. The proposed expansion is set back far in excess of the required yard provisions. The concerns with regards to the trailer and management of water and other business aspects are unrelated to the expansion in lot coverage. The use of growing food can occur whether it's in a greenhouse or not. The variance permits the expansion of a greenhouse and it does not prevent the expansion of the business itself. The greenhouse simply ensures a better yield, which supports local food production and security. The variance at an increase of 10% is, in our opinion, highly supportable and suitable to support local food security and represents a change in the size of the greenhouse structure itself. So those are the 4 tests. We have read through all of the comments that have come in, planning comments, as well as neighbor concerns. And I would just like to comment, and my client's here to speak to it as well, that they've been very good neighbors. They've gone to their neighbors. They've discussed, various ways to improve general site management that's unrelated to the request here today. And all of that has been worked out and being worked on, and additional trees have been discussed to be planted as well for further buffering. So I'm happy to take any further questions from the committee or otherwise. Thank you.
Okay, thank you. Planning staff, please.
Thank you, Chair. So the staff report, as submitted, states that we have some concerns with this application due to the scale of the requested variance. So 30% lot coverage on a 9-hectare lot is quite significant for this type of building. This designation seeks to have low intensity uses, and it is staff's opinion that this use may will increase the intensity, and whether or not that is still low intensity or not is up to the committee.
Thank you. Members of the panel, Mr. Vervoort or Mr. Otto, any questions, please?
Just for planning staff, I noted there was a comment regarding employees house or potentially housing employees on site. Is that a relevant concern for the committee? Or is that a bylaw enforcement matter?
My understanding is that would be a bylaw enforcement situation, and that staff would recommend that the applicant seek a zoning bylaw application to seek to permit farm help on the property, but that is unrelated to the variance request today.
Thank you.
Mr. Otto, any questions?
No questions, thank you.
Any closing comments?
Thank you, Mr. Chair. With regards to Mr. Graham's comment, the zoning issue will be pursued separately. But the variance today will allow them to capitalize on the current growing season in order to meet the demands for local food production that they are offering in our community. And just before I sign off, I don't know if Ms. Taransky would like to say any comments.
We are.
If you can move the microphone over,
Oh.
please.
I don't know if you're aware, but we have only owned the property for 2 years, and we have undertaken a number of improvements to the property itself, and we are well aware of what needs to be done. And it's not that we're not looking to do add extra trees and such. It's a time of being able to do it. And as when we purchased the property, we had hoped to expand in the future, but we have come to find that a 2-acre expansion, or the 10%, would help us round out what we can provide to the local residents. And there is quite a, the demand is increasing for local product. And that's one way we can do it, is by increasing. And that also allows us to improve the property as well.
Panel members, any questions arising out of that? No questions. Shall we reserve? Reserve? Yes, thank you very much. It's reserved.
Thank you, Mr. Chair, members.
You
of the
will hear
committee.
from us. I guess we're back to Campbell Road. Mr. Robinson et al.
Hello again.
Oh, so this is the application time.
Okay.
And the floor is yours.
Thank you very much. If the coordinator could put up the PowerPoint, please. Thank you. So the application before you today for Campbell Reid is by A&G Olander Holdings. And what you can see there is architectural elevation drawing of the exterior of the building for this veterinary clinic. Next slide, please. This is the subject property outlined in blue. It has frontage on 3 roads. At the bottom has March Road. On the left-hand side is Dunrobin Road. And on the right-hand side is Campbell Reid Road. There is an existing house, which is where Dr. Robert Olander lives, and that is Dr. Andreas Olander's son. So he's a veterinarian as well. They are in a veterinary partnership now, and the intent is to build a new veterinary clinic on the west and southwest portions of the property, with a site access to Dunrobin Road for the veterinary clinic. Next slide, please. At the top right, the image that shows the existing home on the property, and you can see some red lines, which are the property boundaries. And then the image on the left and bottom left is a drone photo taken of the property, and you can see the frontage on Dunrobin, and where there is an existing site access is where the new site access will be for the veterinary clinic. You can see March Road as well at the left-hand side of that image. It does have frontage on 3 properties and 3 lots, 3 roads. And zoning regulations in the city require that the lot width be taken at the required front yard setback from the frontage that is the narrowest. And in this case, it is Campbell Reid Court. Next slide, please. These are the from the official plan. And then you can see on the left is the future neighborhood overlay is shown in a purple outline. All the area between the purple lines and the black line are the lands that were added by the province after city council did not expand the urban boundary in this area. The province had about a year to look at the city's version of the council approved official plan. They added some urban boundary lands, and this was one of them. And then you can see on the right-hand side in the purple hatched area, you can see the areas that were added to the urban boundary. Our client's property is at the very northern extremity of that in the red dot. It's about 700 meters from the previous urban boundary, and it's about 1.3 kilometers from the edge of the serviced area of Canada North. One of the issues is that you could only develop in this area as a site plan if you did not need any variances, and we need 2 variances, and they're related to lot area and lot width. And as Mr. Vanderland will indicate, there are modifications underway that will be coming forward to Planning Committee and ARAC and Council in July that will rectify the issue. Basically, any lands in the future neighborhood overlay can only develop once a series of planning studies and infrastructure studies and traffic and so forth studies are done, unless you can develop without any variances. Next slide, please. This shows the current edge of the urban boundary. It's just north of a Catholic school and a Catholic church on the west side of March Road. It's about 700 meters to our client's property. And then the image on the right is the same image, but it shows where the current extent of urban services are, which is 1.3 kilometers. We're proposing to go forward on well and septic, and it would require an extension of 1.3 kilometers for services otherwise. Next slide, please. This is really the crux of the variances that are being sought today. The property outline is in red. In this zone, the required lot area is 0.8 hectares. Ours property is actually 0.79 hectares, just under. Yep.
Sorry, the time's up. How much more time?
A minute and a half.
Minute and a half?
Yeah. Thank you.
All right, members, that's fine.
Thank you. So the property size is 0.79 hectares. It's just slightly under. It actually is the biggest property on the entire street of Campbell Reid. So there are no other properties that are zoning compliant. In terms of lot width, it is measured at the front yard setback of the narrowest frontage. The required is 50 meters. We're at 25.84, which is where the blue line is measured from. And as you can see, as you get further back, the property lines do diverge. And I would imagine that once you get beyond the house on the property, that you do achieve the 50 meters. So it's not really a significant issue. It's just a matter of where you measure it from. We have more than 50 meters of frontage on the other two roads, but we don't have 50 meters of frontage on Campbell Reid Court. Next slide, please. This is the site plan. As you can see, there's a building of approximately 5,000 square feet proposed in the southwest corner of the property, parking to the north of that, and then the site access for the veterinary clinic is only on Dunrobin Road. So it will not be coming in and out of Campbell Reid Court, which is primarily a residential street. Next slide, please. This is the landscaping plan, similar site information shown, and you can see where the lot width is measured from, and you can see the lot area. Next slide, please. These are some slides taken along Dunrobin Road from the approximate entrance to the veterinary clinic. Another one in the middle looking north on Dunrobin. The third image is looking from the interior of the site towards the Dunrobin Road access point. Next slide, please. This is on the left is the existing house that's on the property where Dr. Robert Olander lives now. And on the right, this is taken from approximately in the middle of the property, looking back towards the rear of the home on the property. Next slide, please. Some architectural elevations of the south and east elevations of the building. And I think there's just one more slide. These are the other architectural elevations. We're into a site plan approval process on this. We're nearing the conclusion of that process. And we'd like to have the application for the variances heard today so that we can keep on moving along on the site plan process. Thank you.
Thank you. Planning, could I have your comments, please?
I'll begin by addressing the variances requested before passing it to Mr. Van der Linde about the official plan policies. So in terms of the variance requested, the lot area is a very minor request. We have no concerns with that. And the lot width request, we understand that this is a unique property layout and that the request for the lot width variance is also, staff do not have concerns with that. The major concerns lie with the current policies requiring the removal of the future neighborhoods overlay before approval can be sought. So I'll pass it to Mr. Van der Linde to speak to that.
Mr. Chair and members of the committee, I'd like to speak briefly about the changes to the official plan that are being contemplated and will be reached at council sometime this summer. I can't confirm that it's going to be on the July agenda because we have not gone through the agenda clearing. There's a bureaucratic process relating to that, so I can't guarantee it, but it is imminent. It'll be part of the omnibus amendments. We're preparing a series of minor corrections, omissions, and clarifications to the official plan as it was approved by the minister last November. We have about 100 items on there. The technical circulation has been out for more than 28 days now. It actually ends today. I've not received any comments relating to this or other matters aside from those from the applicant. We are sensitive to not only what has happened on this property, which has unfortunately been caught by the actions of the minister to add additional lands. So they were caught flat-footed, and we're sensitive to that. We also have an understanding that we perhaps at a policy basis have been a little bit too strict with our provisions to prohibit development applications in the future neighborhood overlay. Just to give you a little bit of a background, when we add additional expansion lands to the city, we really don't want to see the parcel sizes and additional uses generally brought on. So we discourage consents and applications for plans of subdivision, absolutely forbidden. However, understanding that we have somewhat less than 2,000 square, so about 20, somewhat less than 20 square kilometers of development to plan for the next 25 years. it is reasonable to suggest that a number of properties will be held and not changed, but uses will change and properties will change hands during that period. So it's our intention to allow for minor variances and permissions and applications, minor applications such as that, to allow a minor development to exist on lots that exist prior to November 4th, 2022. That policy will be coming forward. We feel, the second component is the minimum lot size requirement. There are minimum lot size requirements vary across the city. If you're on private services and in the rural area, so and it you'd be fully aware of, minimum lot size generally is 0.8 hectares. But however, within villages and within the urban boundary, 0.4 hectares is permitted. I can expand on the basis for that, but we feel that that does provide for a safe, clean, and sustainable water supply in perpetuity on those lots. And in cases such as the applicants today, where we know that a 1.5 kilometers of water main needs to reach it, it's going to be a while. So we will be changing the policy, or it is proposed to change the policy to allow 0.4 hectares as the minimum lot size in future neighborhoods, which is reasonable, we feel, as these lands are technically within the urban boundary. However, they sort of fall within a sort of a policy trap as it is right now, based on the zoning. I'm free to answer any other questions relating to policy or policy intent.
Just wondered, panel members, do you have any questions of the planning staff?
I just had one question. If we were to approve this and make it conditional upon the OP being amended, would that, I guess I'd like to hear from the applicant on that.
I know that Member Vervoort, as you've been on this panel a few times, I believe that generally the panel is reluctant to put conditions on minor variances. Often it's standard, and there was one heard earlier today, a severance application is pretty standard. We also have a site plan application that this is tied to, and I'm wondering if it might be more appropriate to have the approval of the official plan housekeeping amendments that Mr. Vanderland has spoken about, that they need to be heard, approved, the appeal period ended before the site plan agreement can be executed.
Is that a condition that you want in there? I'm not clear, Mr.
We
Robinson.
we would prefer if Member Vervoort had indicated.
Yes.
That the OP modifications have to be in full force and effect before the site plan agreement on this file is executed. Due to the size of this project, there is a site plan application where we're coming to the conclusion of it, and that it as Member Vervoort knows, it's hard to tie down conditions on a minor variance, and that this panel, I know, has been reluctant to enforce or impose those on minor variance applications.
Yes, thank you. Does planning staff have any comments on that aspect?
It's my understanding that we could impose a condition on this minor variance, and that that condition would be caught at the building code stage. But it's up to the committee whether we impose that condition.
Okay. Members of the panel, any comments, questions?
My only question would be, in regards to that, is it going to speed up or slow down the process if we put that condition in? Because you mentioned you were in a hurry. And if we delayed this until council did pass everything else, I think you're going to be in the same boat if we put that condition in. That's just, I'd like your comment on that.
We would prefer no conditions, and that this process wrap itself up, and then the official plan housekeeping amendments are also sort of going just a few weeks later. And as we don't want any hold up on site plan approval and building permit approval. So if there's a way that we can, putting it, a condition, any condition on this, does run the risk of, slowing us down.
If I may, Mr. Chair, may I make a point? Mr. Graham, I think you had the solution and I might have not quite understood it, but I'm in agreement with what Mr. Robinson just said, that we'd prefer if the committee would support these two minor variances without condition. But I believe there is a separate process that you're referring to, Mr. Graham, that would in fact subsume this.
I'm not sure if I understand what you're suggesting.
I think if the committee does see fit to approve these two variances, I believe that the city of Ottawa still has, and I think this is what Paul was getting at, I still has the ability to review the matter at site plan agreement stage.
That's correct. The site plan approval has not been issued, and the approval could catch that sort of issue at that stage.
Thank you.
All right. Any further, Mr.
I'm just gonna say, it appears to me then that, I mean, for the committee, there is not current compliance with the official plan requirements, but I guess the direction or the indication from the city is it's pretty clear that this is going to be corrected. We've dealt with other problems in the official plan on this committee before that are still outstanding as well. So that's my understanding. Is that correct?
That is correct. I've been directed by council to address this matter.
Okay.
By
Well,
motion.
in that case, then I don't have any concerns. I just wanted to clarify. Thanks.
Okay. Is there anybody on video? I know we had one comment and I can't tell if there's anybody that wants to make a comment on video. I don't think so, but I'm just asking.
No, Mr. Chair, there does not appear to be anyone online.
Yeah. Okay, thank you. So members, shall we reserve on this matter? Yes. Yeah, thank you very much. Thank you very much.
Thank you,
gentlemen.
Mr. Chair.
Appreciate your words and thoughts.
Thank you.
Is that it, staff, for the day? Yes.
Yeah, that's all the applications.